Damn, y'all. The recording shut off, right? Stop by itself, y'all. And then it start replaying again. It stop pauses for a minute, then it continues to keep recording. I'm thinking, I'm hoping. So I always gotta say this every time it does that. Um, I just talk. I've been showing y'all about the policy in the last video or whatever. Or hopefully it's all one video. So I'm gonna keep doing that. Let's hurry up though, cause I think I've been recording a whole lot more than yesterday, y'all. I got shit to show y'all. Man, y'all can see the policy, man. You can go get it yourselves, man. Let me show y'all my emotions, man. My painting. Beautiful paintings. You know what I'm talking about? That's what I call them. Beautiful paintings. Come on. Yeah. Last page. Come on. Go. So, move this shit out the way real quick. I just want to show y'all a few emotions, right? Real quick. We done with this shit. I gotta try to get going on the other shit, man. Alright? Oh, so this is what happened, right? So, this right here is called excuse me, I gotta get some water. Right, so this is called a so with William Kaufman, with the one of the two defendants on his lawsuit, have my hair. From the beginning, when I filed the lawsuit, his answer, they gotta answer you back within 21 days, like I showed you on the summons, right? Right over there. Um, he didn't want to refute the claims, but he didn't want to when you settle, when they settle, you sue somebody, a settlement, they say under the settlement rule laws, whatever, right? It says that we're not just because we want to settle, we're not saying that we're guilty. We're not saying that we're not guilty. Or we just want to get this over with, right? Basically, to make it short, right? And sometimes people do that when they're not guilty, right? Right? Sometimes people just got so much shit going on. It's a process. Sometimes it can hinder your process. You got other business going on, right? And you just want to, you're guilty, but, you be like, man, let me just get this nigga, you know what I'm saying? You got something coming, right? It can be either or. Sometimes people really don't be guilty when they just want to settle. It doesn't mean you're really guilty, though. But in this case, that nigga guilty than a goddamn but man, come on, bro. That nigga guilty, man. You can't get no more guilty. I'll just say that, man. So everything I said, all facts, like I told you, right? I ain't lied on the man. So other than that, um, yeah. So this is what I did. It's called you gotta. I mean, people don't even know about, but I just kind of like, sometimes I meet people that know about law, and I know about law. Most of the time, they just learn and get way more info, knowledge, and ism from me than I receive from them. I'm be honest, but you know what I'm saying. So that's good. I like running into people like that, man, in jail, prison, right? Um, so this is a conference, a confidential settlement conference, because he wanted to settle from the gate. From the gate, as soon as I filed a lawsuit, he's like, let's do a settlement. You know what I'm talking about? But the other dude, he want to fight because them claims really, those was more harsh. You know what I'm saying? Those was more, come on, man. You already, you seen it for yourself. So, man, that's page one. Page two, right? Now, let me tell y'all something, right? Remember I told you the judge, and in the order of the motion, I showed you the order of service, my Rule 46 motion I filed, uh, objecting to the judge's order or judgment, you know what I'm saying, or ruling in whatever it was for whatever situation. It was because, remember I told y'all, the judge only held him to answer to one fucking, I'm talking about one fucking claim out of 3, 4 claims I put. It was only used excessive force. Feel me? So I'm telling him, I'm still in this. I'm telling him, look, bro, you know what you did. I know what you did. You know what the judge did, the court, kangaroo court did to help you out. Made you answer the one claim when it wasn't supposed to. But I'm still telling you, I'm standing on this. I'm going off this. Nigga, you know what you did, nigga. So when, for as part of the settlement, nigga, I'm including this shit, what you did to me. I don't give a fuck what that kangaroo court, corrupt court did and hold you, or only held you to answer the one thing, one claim out of 3, 4 that I put on you, right? And I had on you, you know what I'm saying? Legally, right? So I'm telling them, bruh, this is what you did. Plaintiff hereby submits this memorandum in support of his confidential settlement statement. So basically, I'm telling them, right, you don't have to do this. No, you do have to do one, right? And you got to figure out how to do it. So I just kind of like went along off of some other shit, and uh, basically, I still incorporated those claims, and I told them, you know what I'm saying, that's what you did, man, and sure, and based on that, I deserved the amount of money later on. I'm showing on the other pages. Look how I broke it down, man. Core chemical agent expert under rule can testify to severity of being pepper spray, thus requirement met for duty and owed by the sheriff deputy to examine and treat injuries. All right. So I'm telling them, okay, each claim, peep this how I do. Delivered indifference, right, for medical, right? I'm explaining the claims that I could bring and the defenses that he could use as a defense. But if what he did doesn't go under that defense, nigga, his defense is not adequate. You feel what I'm saying? So, bam. I just let y'all read this shit, man. See, this type of associated injuries that you could get permanent vision problems, blistering of the skin, uncontrollable gagging, etc. See, although being pepper spray may not be classified as serious because it's not in a federal serious physical injury, does not absolve nor does it abrogate sheriff officials' duty, power to promptly provide necessary medical treatment as plaintiff were injured and harmed. Off top. Short statement of facts. Defendant called me to use excessive force, retaliatory misconduct on April 7, 2017 against plaintiff with sole intention of inflicting pain and injury on plaintiff when he also refused plaintiff to seek medical care, which is a deprivation of treatment. Then the retaliation claim. Here, plaintiff contends that and an informal complaint, right? Federal in the lawsuit, along with an intent to sue him. See, I explained to him, right? I'll let y'all just read it, man. I might lose you. It's better just to read it yourself. You probably understand. Sometimes it's better when someone is doing that instead of hearing what somebody's saying. I'll let you just read. I'd be doing shit hella fast because I'm working on 5. Let me tell y'all, you know why I be fucking up too? Because not only that, is more that what these devils put up inside of me, it be fucking me up. You know what I'm saying? Like it be fucking me. I'm gonna talk about that later on. Talk about that right now. It's gonna go over your head. The shit, that white devil shit that the government done put up inside of me, in my head, in my body, right? Bruh, I be fucking up so much while writing. That's why you've been seeing some shit. It's not that I'm in a hurry. It's that I'm gonna talk about that later, man. I'm gonna go off subject. Feel me? I'm explaining to the federal courts the type of defenses he has, right? And if he did, and if his actions consist of it fell under those defenses, then I'm not entitled to nothing. I'm telling him, I'm playing fair square. I'm telling the judge this, right? You see what I'm saying? You don't even probably see plaintiffs or real attorneys doing this type of shit, man. Real talk. I'm telling them this is the defense they got. Well, no, they probably, maybe not. You never know, man. I taught a whole bunch of them. Anyway, so bam, I'm telling them, look, basically in all, under laws, all types of law, Ninth Circuit, model jury structure, civil rule, everything that the defendant's conduct had no penological objective reasonableness. Therefore, he is not entitled to qualified immunity. Qualified immunity, what they call, it's a legal terminology in courts, federal courts, and all that shit. We all know what immunity is. It pertains to you don't get in trouble. You know you can't be held for anything, whatever it is, situation. All right, they call it qualified immunity in civil courts for you know what I'm talking about, for law enforcement. Relief Sir Herman Tom Rott has authorized an initial demand in amount of $230,000. That's at the least. Mr. Thomas has not drawn any lines in the sand in terms of damages, but he does have expectations that far exceed what defendants have typically offered in a prisoner cases. You know what I'm saying? Prisoner cases, right? See, plaintiff Stacy were at the time wheelchair bound and suffered fracture to his rib, which caused him extreme pain during his uncontrollable coughing, gagging from the pepper spray. When he pepper sprayed, this like continuing to harm me each time I'm coughing. So, anyway, let me go. I gotta keep going, man. I don't get too done. I'm probably gonna have to order some type of food, man. Fuck. Unless one of you worthless ass bitches wanna come cook for me. I edit that out. I just fuck, you know what I'm saying? I like, I'm probably gonna have to edit that out. I don't know. It sucks me crying over anything, including the truth. You know what I'm talking about? Respectfully, y'all. Respectfully. I mean, I should have had a maid and a chef in a big ass mansion already. You know what I'm talking about? A butler and all that. But I like cooking myself, though. I'm gonna be honest. Fuck all that. I'll be in the kitchen too, though. Oh yeah, this is the awards, right? See, when you submit this paper, y'all, gang, y'all gotta be on point with this. Cause they won't see, they took me seriously, I'm gonna be honest with you, but they just didn't respect none. They don't really care. They already felt nobody's gonna help me. They could just cheat me to beat me, and that's it, dismiss my case. But they're supposed to take you most seriously. The more you present your case, how you present it is how they take you, whether how they gonna take you seriously or not, right? And how I presented my case, every case, nigga, they're supposed to take me seriously and respect game. But anyway, see how I present on top of my awards. You got to do real research. You just can't give them a fucking certain number, throw out a certain outlandish number of award that you want, right? You have to do this. How they tell you most. You do your own research and you present to them type of settlements, right, and or jury awards plaintiff has received relating to your claims. You feel me? In your lawsuit. So that's how you're supposed to. And you got to do Ninth Circuit. You got to do Ninth Circuit awards or settlements or Supreme Court cases. You feel me? Not no other circuit district. Man, I'll tell you, it's a whole lot to this shit, man. They will hit you with fucking all types of technicalities and, but it's a dirty game. I'm trying to tell y'all, man. You better know all this shit and more. I ain't even talked about everything yet. So I brought that up, but awards and settlements, I also just included this. That's from right. Champion versus Outlook Nashville Inc. He received 900,000 for pain and suffering during police abuse that ultimately caused death. Woo woo. You know what I'm saying? So you could put certain things that kind of pertain to you, not fully. It don't matter. Nigga received 300,000 over here. It's best to do Ninth Circuit, but like I said, sometimes they say even the courts will tell you if you can't find stuff that relates to your case for your presentation, motion of opposition, awards, whatever you want to present, right? Then you got to use other circuit cases. 25,000, 5,000. All right, my shit's serious too. Oh, shit, it's the other page. It's on the back too. These are all awards. See, upholding $100,000 compensatory damages and $150,000 in punitive damages, where complainant alleged he was a prisoner whom was restrained face down for 22 hours, 22 and a half hours, also physically abused by by staff, right? There's all types of shit in here, right? So, 3 or 4. All right, last page. In a settlement, this dude received Padilla versus Beard. That's case number Eastern District, California. That nigga received $950,000 settlement, but probably don't want to know what happened to him. You know what I mean? Sometimes money don't cure everything, bro. If you a vegetable, what the fuck you gonna do with money? You know what I'm saying? That's just one example. Alright, that's it on that, y'all. Down another thing real quick. I don't know if I'm another one. Alright. So there's some other shit that I found. Right, some good handwriting right here though. Come on now. There's a whole bunch in there that is. But I just, sometimes I just be like, sometimes I just don't care, man. But, right? Also, what they did, the federal courts dismissed Sheriff Deputy Reed, on all claims. After I presented so much damaging evidence and all that, dead bang smoking gun, right? Deputy Reed, he got dismissed. All claims, dismissed the whole lawsuit on him, right? On him, you know what I think? I'm like, bro, if this defendant didn't want to settle automatically, if he just denied all claims like Deputy Reed, his coworker, did, the judge would have fucking let him get away with it too. So I'm like, I don't know, man. Dude being fucking accepting responsibility or what? But I'll tell you one thing. All I got was 12,500 off that settlement, right? I just settled, man. I said, fuck it, man. Let me just get that chunk change. I need some money right now, nigga. I'm fresh out of false imprisonment. Nigga, at that time, the federal government utilizing T-Mobile and Bank of America, they wiped out all 4 of my bank accounts and other, 4 separate bank accounts. You know what I mean? I barely had to file small claims court lawsuit, right? I basically lost 4,000. I recovered all the other money, right? Most of the money, except for 4,000 from Bank of America, right? and then 1,600 on another bank account that had to do with Bank of America on another credit debit card, another separate account, 1,600 and something, and then some other stuff, right? So I still lost out on a lot of money, a lot of thousands, bro. I didn't get everything fully, right? You know what I'm saying? All while I was falsely in prison, bro. That's what these suckers always do. And then, man, come on, bro. I'm gonna talk about that later on, yo. So, bam, I'm put all this there. See how I'm talking this though? Cause I'm telling the United States Court of Appeals, Ninth Circuit, I'm telling them to stay the lower court, which is the United States District Court, right? For William Kaufman, because I stated a claim, a bunch of claims, right, that he should have been held to answer to. And I was talking about that earlier, but the judge being a kangaroo court, right, she only had him answer the one claim out of three. So I told him, I'm preserving my rights and appealing this shit, right? But I just settled anyway, so after all, you know what I mean? But look how I talk this shit, though. Every time I'm filing documents, bro, I'm whooping their butt, man. I'm stepping on them, bro. Like, you know what I'm saying? These high-priced attorneys can't even fuck with me. I'm gonna be honest with y'all. I be having these high-priced attorneys scrambling like cockroaches. Maybe turn the light on. Boop. You know what I'm talking about? Man, I be really doing that. That shit's crazy. I mean, I ain't crazy. It's hard work, man. It's what a nigga, you know what I'm saying? What hard learning we was doing, man. I'm doing. Hard work, though. Look how I talk this language, though. Come on, man. The way I eat them up, the way I prove my points. See that? You pause it and read that, man. I ain't nothing, don't worry about that. There's some other shit too now. Look. Now, since on a Kaufman, right? On the one that wanted to settle, we couldn't reach a settlement. You know what I mean? So for a while, right? So we were forced. The judge orders us all parties to go to jury trial, right? You can't settle on and let the jury decide whether they want to cash you out, you deserve something or not, right? So that's what it was. So at that point in time, at that stage, I came up with this, right? I'm like, I gotta disqualify this judge to preserve my rights on appeal because this judge right here, senior district judge Phyllis J. Hamilton. Man, come on, bro. Oakland, California. This broad is gonna fuck me real good even more. I said, man, look, bro, we can't have this cockroach on the panel, man, on a presiding over this case, man. So to preserve my rights on appeal and all that, every time, because I see that's what I needed to do against these corrupt individuals. Where I'm like, I gotta I gotta throw all my bullets. You know what I'm saying? I gotta throw everything at him. You feel me? So I filed a motion to disqualify the district judge and memorandum of law in support thereof that I had. I want to read this real quick. Plaintiff Herman Tomrat hereby moves Judge J. Hamilton, Phyllis J. Hamilton, pursuant to 28 U.S.C. United States Code, Section 144 and 28 455, to immediately disqualify herself from all future proceedings in this manner. In support of this motion, Mr. Tomrat says for the following facts and argument background. Plaintiff has brought four separate, because I dismissed one I told y'all by myself. I said, man, it's too much work, so I dismissed one case myself. All that. Plaintiff has brought four separate complaints in the United States District Court. You can't read this, so I'm reading it. I messed up on the original. It's better, though. I mean, on the other one. Plaintiff has brought four separate complaints in the United States District Court, Northern District, parentheses. All cases assigned under one judge. This motion is brought forth in connection with the district court's evident bias against plaintiff, the numerous prejudicial actions, and I wasn't finished, right? Against plaintiff courts, the court manipulative practices, failure to hold defendants to perjury, frivolous claims asserted to judgments that hold no merit. That's against the court. Her frivolous claims asserted to judgments that she made against me that hold no merit. Conspiracy, can't read. Illegal and unethical justifications for all defendants in all four separate complaints, lawsuits, and deliberate dismissing of matter of law. That's they talk, all this shit. All herein proven on all relating papers submitting, including plaintiff's appellants and formal opening briefs for United States Court of Appeals case numbers. In connection with above facts, the district court denied plaintiff to fully develop the record. That's they shit. Fully develop the record. You know what I'm talking about? Concerning defendants' illegal manipulations to video exhibits and or utilizing deep fakes. Come on, bruh. Deep fake video footages and or plaintiff's discovery stages, right? Y'all just barely started talking about deep fakes, man. What I say earlier. I've been talking about this and on other papers, man. They call it deep fakes. AI generated computer program videos. Man, it looks more real than a real video. The fake video looks more official and better than a real video. The fake video. That's what deep fakes. They're crazy. The Congress barely talking about something about another thing. I've been talking about this shit. I've been talking about this shit years before all this shit. Before this country's talking about it even. You know what I'm saying? Because the government been on shit like that, man. The federal CIA, all these suckers, they've been doing shit like that. No, it was all classified. Nobody knew about this type of shit. Now people are starting to know about it. You know what I'm saying? Even companies, you know what I'm saying? People didn't know about this type of shit, man. I was on this shit because I tried to figure it out for so long. How the fuck are they doing this shit? You feel me? You see shit like they'll make a video of you. Your voice is the same. Nigga, your looks could be the same. But you know you didn't do that. You know you didn't say this, right? You know you weren't there. You know, man, come on, bro. That's that deep fake shit. Man, it's right here, bro. Come on, bro. Stop playing with me. Deep fake video footages. Man, all types of shit. I've been talking about it. You see it later on. But anyway, I'm going on that, man. Yeah, man. What Congress, all y'all newspapers, y'all barely talk about this shit, man. Late 2023. Come on, bro. Basically 2024. I'm teaching him what the fuck this shit is, right? So when you file so I had to file a notice of appeal. This is what that looks like. It's short and simple. This is what you do. All right. to the appellate courts, right? Higher court. I wrote down hella shit like why, you know what I'm saying? All types of shit. But anyway, alright. It's the other shit, right? It's my second motion, but this is to the United States Court of Appeal. I'm like, man, I got so much shit going on. Fuck it. I take my chance with an attorney helping me, or at least helping me. I'm gonna do most of the work. I'm just gonna have him. Usually when I have somebody represent me or so called, I'm doing all the hard work. They just doing all the typing and all the shit, man. I'm really the one protecting myself and executing my case, man. I'm be honest with y'all, bro. This is what a motion for appointment counsel look like. You feel me? 28 USC, woo, woo, you know what I'm saying? Type of shit you gotta put on there in order for them to grant it. The courts always have to, goddamn, they could just deny you this if they want to. It's fucked up. Fuck John Burris law officers too. Fuck John Burris. Fuck all them, really. Come on, bro. Yeah, well, anyway. So, hey, look. In my first one though, I gotta point something out to you. But the other one, like I had to redo. Man, I was talking about some shit. So you know I'm not playing, right? Keep game, right? I'm like shit it's gonna fuck me up because it's gonna affect me, and I'm gonna tell y'all later on. See, in here I cut it hella short. I broke down all the stuff how it affects me though. That paper is missing. I don't know where it went, right? I wrote it to the fucking federal courts while I'm asking for counsel, right? Because I'm seeing hella shit that it's doing to me, right? What they put up in me. I said, look, man. But also since being subject of harassment amongst other serious violations to the U.S. Constitution, customary international law, and human rights by the FBI, Oakland Parole Unit agents, and or Sonoma County Sheriff's Office jail facility staff conspiring alongside above mentioned government agencies by illegally planting, placing through. I fucked up, not just third party, but they directly did it. Some undeniable,